thank you for this very nice introduction indeed. So I've been asked to provide you with an update as to the legal framework in which the privacy shield should be adopted in 5 to 8 minutes, which is quite of a challenge, but I'll try to succeed in doing so. So basically, as you probably know, but well, let me refresh minds in that respect. This is about Article 25 of the European Directive on Privacy Protection, which permits the Commission to find that certain countries or specific countries, such as in the case United States, ensure a satisfactory level of protection for privacy and people's fundamental rights and freedoms. Such finding can be reached by the Commission after negotiation with a country, and certainly after examination of such countries' laws, practices in terms of protection of privacy and fundamental rights and freedom. So it gives the Commission the possibility to talk to the country at stake and to try to reach common grounds as to the way both parties see the protection of privacy and would indeed enforce such protection, well, especially in the country the Commission is talking to, such as the United States. Well, initially, this has led to the Safe Harbor scheme that was adopted by the Commission and the US Department of Commerce in 2000, and the Commission found, pursuant to a decision of 26 July of 2000, that such a Safe Harbor scheme, would indeed allow to ensure a satisfactory level of protection for privacy and fundamental rights and freedoms. Article 25 of the directive has to be distinguished from Article 26 of the directive, which also allows to, which also allow, if you want to, find that certain legal instruments other than an adequacy decision of the Commission would indeed allow to transfer data to other jurisdictions, such as the model clause, which have already been mentioned, the consent of the data subjects, or binding corporate rules. The main difference, or the biggest difference between Article 25 and Article 26 is the fact that under Article 25 there is a discussion between two jurisdictions, the European Union on the one side and the country at stake on the other side. While under Article 26, this is a justification which will be valid, if you want, in general, independently from the country data would be transferred to. As you know, the European Court of Justice has decided on the 6th of October 2015 that the Safe Harbor decision of the European Commission was not well-founded, and it in fact invalidated the decision of the European Commission with respect to the Safe Harbor scheme for the main reason that the European Commission had not expressly found that the United States would ensure a satisfactory level of protection for personal data. I insist on the fact that the European Court of Justice did not make a judgment call as to the effective level of protection of personal data in the United States, at least, or especially for data originating from the European Union. The European Court of Justice mainly or simply found that the European Commission did not look, or at least did not mention in its decision of 2000 that the United States would indeed ensure a satisfactory level of protection. So it was a purely, from the European Court of Justice point of view, a purely formal point or issue that was considered for invalidating the decision of the Commission. Besides, the European Court of Justice also decided that national supervisory authorities would indeed be allowed to look further into practices and the reality of the situation on the ground in the United States, for instance, to decide, or at least to assess whether or not a satisfactory level of protection was indeed ensured in such jurisdiction. It being noted that the European Court of Justice also reminded the supervisory authorities that it was the only authority, the court was the only authority that's entitled to annihilate or to invalidate a decision of the European Commission. before the decision of the European Court of Justice, talks had been reinitiated between the European Commission and the United States to strengthen the safe harbor scheme because, well, one had noticed certain gaps, if you want, or weaknesses in the scheme. Definitely those discussions accelerated after the Trump decisions, and we now have the Privacy Shield, the draft decision of the European Commission on the Privacy Shield that was published in the course of February of this year. Definitely, if you go through the Privacy Shield as it currently stands, you will notice that there is a significant emphasis on the review of the US law and practice with respect to privacy and and monitoring or surveillance activities of the US government. And definitely the purpose or there are a number of achievements, if you want, under this draft decision of the Privacy Shield when it comes to reinforce the principles that have been set forth under the Safe Harbor scheme and to reinforce as well the possibilities to indeed enforce those principles via the US authorities, such as the Federal Trade Commission, or even via the European Data Protection Supervisory Authorities, to which US entities may be subject to, may be declared that they will be subject to in some instances. The Privacy Shield has definitely unique features, one to which we should pay attention and to which a number of stakeholders should indeed pay attention. First of all, it's important to underline that this is about finding that an equivalent level of protection will be ensured in the United States compared to what such level of protection is within the European Union. It is not about finding that an equal level of protection is enforced in the United States. It's about finding that only an equivalent level of protection. That's important because there is clearly a tendency of a number of players in this field to look for something totally equal, if you want, on both sides of the Atlantic, which seems to be a difficult agenda considering the starting points of both parties, with different legal cultures, if you want, in terms of privacy protection. It's also important to notice that the discussion around the Privacy Shield between the US government, the Department of Commerce, and the European Commission gave to Europe a unique negotiation position with respect to the US practices in terms of privacy protection or surveillance activities and so on. I don't think there is any precedent where a jurisdiction such as the United States, if you want, has been so transparent, relatively transparent indeed, but transparent still with respect to its surveillance activities and in terms of opening a number of procedures, if you want, that are available to US citizens to European citizens as well. If you think of the positions taken by the Obama administration at the start of the Snowden revelations, for instance, well, the Obama administration never really addressed, well, at that time at least, never addressed the situation of European citizens, well, basically affirming that US citizens were not spied by the government, but what is happening with respect to European citizens was not really in the press releases and in the declarations of the Obama administration, notably the American presidents. The Privacy Shield is important because it put the burdens of privacy protection and fundamental rights and freedoms on the US authorities. And if you consider Privacy Shield versus, for instance, the model clauses, as far as the model clauses are concerned, well, normally the focus is more on the private entities that are supposed to ensure such a satisfactory level of protection. When you think of it, that does not really make sense. If you transfer data to the United States, for instance, or to Russia or to some other jurisdictions, under the benefit of the model clauses, well, do you really think, is it reasonable to think that those private entities receiving data will be the only ones in charge of responsible or that could be held accountable for what's going to take place with respect to such data. The Privacy Shield allows to put the focus on the real stakeholders, the real players in this field, and that is in this case the American authorities, the US authorities that are indeed in charge and who have the power, which have the power to decide what they will do in terms of surveillance and monitoring traffic of data. It's also interesting to note that the Privacy Shield allows US entities, US companies to embrace the cause of privacy protection in a way that puts them in a position that is relatively close to what is going on here in the European Union. So to a certain degree, this is about approximating the US legal framework, if you want, when it comes to data protection to the European framework, which is quite of an effort, indeed, quite of an achievement, if you think of the US standpoint in general as to the foreign effect or the extraterritorial effect of EU laws, for instance. The Privacy Shield, and that was mentioned or touched on by Mrs. Niebler, also allows indeed a number of companies to exchange data in a smooth way, which is not exactly the case for other grounds or other legal justification for transfer of data, which will require, such as binding corporate rules, if you want, definitely more efforts to, well, first of all, have those binding corporate rules approved, for instance, and being put in place. Well, just to make it short and to stay in line with the requirements have been given, what's next? Well, we know that the Article 29 Working Party, the European Parliament, and the European Data Protection Supervisor have already advocated for some renegotiation of certain aspects of the Privacy Shield. We know that the Irish Data Commissioner has referred a new complaint of Mr. Schrems, not against the Safe Harbour scheme and not against the Privacy Shield, which has not been adopted yet, indeed, but against the modal clauses and the decision of the European Commission to find that the modal clauses were indeed to provide a satisfactory level of protection to personal data. In the framework or in the optic of transferring data to the United States under the umbrella of model clauses, and just yesterday or the day before, the US government has requested to be joined as a party to the case pending before the High Court in Ireland. So we can assume that the US government is going to make its case before the High Court of Ireland and before, most likely, the European Court of Justice, to which this case should be referred as it seems. Well, we're still waiting for an opinion of the Article 31 Committee, which is to come next week, if I'm not mistaken, on the 21st of June. And the European Commission will have in its hands, if you want, all the opinions and positions it needs to take a final decision on the Privacy Shield, or to decide to negotiate it further. Maybe we'll learn more about that in the next minutes during this meeting. Well, just a final few words of conclusion. Does the Privacy Shield solve Europe's problem? That's a question that has been put in front of me for this discussion. Well, first of all, is it just Europe's problem? Definitely not. And well, when we look at the way, if you want, that the United States have come to agree on the Privacy Shield with the European Commission, definitely they have made extreme efforts, if you want, to meet the demands and the expectations of the European privacy community. So it's not just only Europe's problem, but to a certain degree the question is a valid one, because Europe has put itself in a corner, if you want, by asking or by demanding, in a sense, that the privacy protection in the United States be put exactly on the same foot and under the same terms as privacy protection within the European Union, well, this is posing a question, if you want, to the US government, which the US government is probably not able to answer totally satisfactorily. It seems very difficult when you see the different approaches taken on both sides of the Atlantic on this topic. It seems very difficult to be able at some point to conclude that the same level of protection, that the same protection is indeed guaranteed on both sides of the Atlantic for privacy and the fundamental rights and freedoms of people. So it must be, and it should remain, a question of whether or not there is some equivalence between those protections on both sides of the Atlantic. Lastly, the Privacy Shield, the discussion around the Privacy Shield is a fundamental one for all those involved in this business of transferring data between the European Union and the United States. If the Privacy Shield does not succeed as it stands now or after renegotiation whatsoever, it's going to be extremely difficult to transfer data from the European Union to the United States, because the criticism raised vis-à-vis the safe harbor and no raised in a minor fashion, if you want, vis-à-vis the Privacy Shield, will stand and will make it difficult to justify that you transfer data under, for instance, a model clause, because well, the data will be at risk, supposedly, or allegedly, if you want, in the United States, as they would be if transferred under the Privacy Shield. I don't think they are really in danger whatsoever, but from a logical point of view, if you block the transfer under Privacy Shield, it's going to be difficult to allow it under any other justification. I thank you for your attention.
Thank you so much, Mr. Fesler, for that very good introduction from the legal perspective. And I now